again brought the issue of judicial accountability and judicial appointments to focus. Has the incident not dented the image of the judiciary?
It is absolutely true that the unfortunate incident has cast a long shadow on the institutional integrity of the judiciary. But it has also given rise to many fundamental principles of constitutional jurisprudence. The fact is that in this particular case, till now, even when the first initial steps in the inquiry process are underway, the judge stands pilloried and condemned, both in the media and by virtue of the punitive transfer to Allahabad and by virtue of the order for withdrawal of work from the judge. I think a time has also come for the Supreme Court to review the in-house procedure to make it more just, to make it more balanced, and to be able to subserve its purpose, which was to protect judges from frivolous allegations and at the same time to provide an effective redressal mechanism to address the ailing issues of the judiciary.
You have been a former law minister, and the original bill for the National Judicial Appointments Commission was also, formulated during your tenure. Do you think the time has come now for revisiting the NJAC, considering there have been many voices emerging, including those from the Rajya Sabha, in this regard?
Well, first of all, let me de-link the questions of Justice Verma's episode from the NJAC. The time for NJAC was ripe in 2014-15 when it was first mooted and put to vote. It is certainly ripe today, and now I am convinced that the processes of public opinion are moving robustly in favor of an alternative mechanism for appointment of judges. It could be on the lines of the proposed NJAC. It could be something better. And I'll tell you why I believe that the time for NJAC is ready. I have a serious issue with the validity of the NJAC judgment, whereby the NJAC was struck down as unconstitutional. The principal reason for the court to strike down the NJAC in its wisdom was that government representatives and eminent persons to be appointed by the government on the NJAC could compromise the independence of the judiciary. In my considered view as a lawyer, and this is the view that the minority judgment of Justice Chalameshwar takes in that case, that there is no equivalence between the independence of judiciary and the manner and mode of appointment of judges. To extend the doctrine of independence of judiciary to the mode and manner of appointment of judges is a flawed extension of the doctrine. For example, where can we derive the presumption that government will always recommend judges that are not first class? And where is the presumption that the judges will select always the best judges? Recent events have shown the reverse to be true. Till date, some of the finest judges to the Indian Supreme Court and in the High Courts were appointed when Government of India alone was the appointing authority. And some of the not very fine examples of judicial appointments have been seen after the collegium system came into being. This is not to suggest that the collegium system consciously selects not the very best judges, but it is certainly an argument to say that the weighty issues of judicial independence, which certainly should be and is a part of the basic structure of the Constitution, could not be extended to the mode and manner of appointment of judges. And as one of the famous American judges said, for how long will the people have faith in the judges who have lost faith in the people and in their representatives? If you start drawing a wedge between judiciary and the executive in the matter of high judicial appointments, a day is not far off when there will be an institutional conflict, and that will be absolutely fatal for the governance of constitutional democracy.
Now that the NJAC has already been struck down by court, do you agree with the assertion that the appointment mechanism will affect the independence of the judiciary, particularly because Parliament, which has supreme powers to formulate laws, had brought the constitutional amendment overwhelmingly approved by the members.
I've already stated that I don't believe that the NJAC as proposed or as could be contemplated for the future, with government being represented by the law minister and some other people being appointed to the committee for appointment of judges, will impact the judicial independence. Quite the contrary. It will lead to more broad-based consultations. It would perhaps lead to better appointments. It is a flawed extension of the doctrine of judicial independence to suggest that in case the committee for appointment of judges has a government nominee or an executive representative on it, the independence of the judiciary would be impacted. Quite the contrary. I don't think that is absolute, that is true either in constitutional theory or in practice.
We've seen in the recent past that various laws passed by Parliament have ended up being challenged in courts. The latest case being the Waqf law, which has just been passed by Parliament, and it's already been challenged by various people. And the One Nation, One Election bill is also likely to be challenged in this regard, considering there is a lot of opposition to it. What do you think on this issue that various laws are being challenged again and again?
Well, this is a very pertinent question, and I think one of the principal issues that this nation and its political and judicial processes have to address in the very near future. We see that almost every major question of political significance and with political ramifications is somehow shunted off to the Supreme Court. It may suit the political executive of the time to have difficult questions being settled by the Supreme Court, or it may even suit the opposition to challenge every measure of the government in the Supreme Court. But it is unfair to the judiciary as an institution. The judiciary itself has repeatedly said that it is no part of the judicial function to enter into the political thicket. That means questions which are essentially political, because the court has said it neither has the mandate nor the means to determine those questions. These must eventually be determined in the people's court. Therefore, when judiciary is called upon to sit in judgment over issues of great political moment, questions are being raised about whether the judiciary is unduly enlarging its remit. The power of judicial review, which was invested by the Constitution in the judiciary, was essentially meant to protect the citizens in the defense of their fundamental rights. It was not intended to be an instrument for the judiciary to nullify the will of the people. And please don't forget that the NJAC, when it was struck down, had the constitutional amendment, the 99th constitutional amendment that brought in the NJAC, had the support of an overwhelming supermajority in Parliament. So at some point of time, can you take away the majoritarian will of the people from the constitutional democratic processes? You cannot. At the same time, you have to temper the exercise of the sovereign will by principles of accountability enshrined in the Constitution. Now, that is the role with which the Supreme Court is charged. But the Supreme Court cannot use that role to progressively keep enlarging its own remit at the cost of Parliament's remit. So these questions are very pertinent questions, and they have to be addressed. And you would have seen that voices are being raised inside Parliament that this can't go on.